Hearing, all persons having business before this court, all their attendance will be shall be heard.
Good morning, please be seated. First case for argument this morning is People versus Jarrett White.
Justice Mitz, may it please the court, Cleo Weiss for Jarrett White. I'd like to do three things in my 5 minutes here. Put the Court of Appeals 2014 decision in People versus Reed into context, discuss the connection between Wren and Robinson and People versus Reed, and then apply Reed to the facts of this case. And the context for this 2014 decision is that there's a jurisdictional split between the federal circuits and also between the high courts of at least 30 states, who address the question of whether a warrantless search is permitted where an officer does not intend to make an arrest, though he or she may have probable cause to do so. New York picked a side in this split, and the Court of Appeals wrote in Reed that where no arrest has yet taken place, the officer must have intended to make one if the search incident exception is to be applied. And Reed is a favorite of the commentators who write law review articles because the Court of Appeals position when they adopted a side in the split is so clear. And so what is the connection with Reed to Wren and Robinson? Analyzing whether an officer intended to make an arrest is supposedly a verboten subjective intentions inquiry. And we've been trained under Wren and Robinson that we can't ever look to an officer's subjective intentions. Wren is not quite so broad though. Wren held that the existence of probable cause is an objective fact unaffected by a particular officer's mindset. Reed itself grapples with Wren and Robinson. It cites to both of them, and it writes that in that case, the Appellate Division decision that it was reviewing erred in extending the logic from Wren to the search incident to arrest doctrine. That's because unlike probable cause, an arrest inherently depends upon a subjective decision. There's nobody who's ever been arrested and taken to the station house and booked on charges without an officer intending that result. So we do look at subjective intentions when we are looking at the search incident to arrest doctrine. And I want to apply the facts now of Reed to this case. The people bore the burden at the suppression hearing of showing that the search of Mr. White's body was proper, which meant they had to show an exception to the warrant requirement. The only relevant exception in this context was a search incident to arrest, but the people in this case failed to carry the burden of showing that there was an arrest or an intent to arrest. And as Reed tells us, where no arrest has yet taken place, the officer must intend to make one if the exception is going to apply.
Why is his testimony insufficient?
So there's one question they could have asked Trooper Ferguson. Did you intend to arrest Mr. White for the marijuana? Because he's got probable cause. I'm absolutely conceding there's probable cause based on the marijuana. If the officer answers yes, we won't be here. If the officer answers no, we have identical facts to read.
Okay, what about the stop resisting? Stop resisting. Doesn't that mean that he is planning on arresting him?
So when you look at his testimony, he stopped resisting as he wrestles Reed out of the car, and then he says, I do a pat down. And he doesn't use the word arrest.
But no, he doesn't use, I agree with you on that. But he kept saying, stop resisting, it's like stop resisting arrest, stop resisting arrest.
I don't know that that's an inference that can be drawn from that testimony. And I would note that this court, in multiple times in People versus Vidal, People versus Fagan, said that the use of force and the use of handcuffs during a traffic stop for a frisk is a Terry stop. That's a level 3 DeBoer stop. So the fact that there's some physical contact between the two of them and the fact that handcuffs are applied to Mr. White during this doesn't automatically elevate this to a level 4 arrest. And I think that when you look at the rest of Trooper Ferguson's testimony, one thing that I think is key is he says this is a probable cause search. Now, that's not a thing that exists under the law. If this officer who seems to be trying to sort of tailor his testimony to our standards, he could have testified this was a search incident to arrest. That would have also meant we wouldn't be here on this question. But the idea of a probable cause search is exactly what is not allowed under Reed. It has to be probable cause.
I do agree with that, but we'll look at all the facts and see.
And just to finish up very quickly, Supreme Court's conclusion in its decision denying suppression writes, regardless of whether the trooper testified that the defendant was searched incident to arrest for the cocaine, the fact remains that probable cause existed to arrest the defendant for the marijuana. That is exactly opposite to what the Court of Appeals instructs us to do in People versus Reed, and I think this court must reverse because that decision is wrong. Thank you.
Thank you.
Good morning, Your Honors. Lisa Gray for the people. I would ask this court to not disturb the trial court's suppression decision. It was absolutely correct, given the facts and the circumstances of this particular case. As you point out, Justice Smith, it's absolutely inferable that as Trooper Ferguson is instructing Mr. White to stop resisting, you can absolutely infer that he is intending to arrest him for the marijuana. There was probable cause all day long in this case, and from the facts that were elicited at the hearing, denial of suppression was appropriate. So unless there are any other questions, I would rely on my
What
brief.
about your burden of proof? How do you people meet their burden of proof here?
Well, to start from the very beginning, there is a valid traffic stop from the observable vehicle and traffic infraction. There's the odor of burnt and fresh marijuana at the time Trooper Ferguson approaches the vehicle. The defendant hands Trooper Ferguson contraband. And he, at that point, is observed putting at least one hand in his pants. He's not complying with, directives to get out of the car. And Trooper Ferguson testifies at the hearing that he is informing Mr. White to stop resisting. So clearly, he's planning to arrest him for at the very minimum, the criminal possession of marijuana. And so, again, the burden at the hearing was certainly met for the minimum for those reasons. Unless there are questions, I would rest on my brief.
Thank you. People versus Lynn Seeley. Good morning.
Good morning, Your Honors.
Please proceed.
Alexandra Hammond appearing on behalf of the appellant. As you, I'm sure, are aware, based on the fact that there are multiple cases in front of you, we are relying on the fact that this is a violation of the appellant's substantive due process rights, as well as his privileges and immunity rights. If there are no questions, I would rest on my brief.
Thank you. Go ahead.
Thank you, Your Honor. Michael Pisco on behalf of the people. Similarly, I know that we've had a number of appearances already, so I'm comfortable resting on my brief unless any of the, unless the court has any questions.
Anybody? Nope. No. Thank you so much, both of you.
Thank you.
Osborne versus Towitz. Good morning. Go ahead. You have to unmute yourself, Robert. Perfect. Go ahead.
Good morning, judges. How are you today? Brian Degnan as the substituted AFC. I don't see anyone else here.
Everybody else submitted.
Okay. Unless there's no questions from the bench, then I would just simply rest on my brief.
There's no further proceedings in family court at this time.
Thank you, Justice Greenwood. Thank you. Oh, I'm sorry. No, there's not.
I wasn't proclaiming that, I was asking.
No, I'm sorry.
Sorry.
There's nothing pending at this point. There's been no subsequent petitions.
I wouldn't do well in jeopardy, you know.
Thank you.
Okay. Have a good day, everyone. Thank you.
Thank you.
341 in the matter of Clarissa F. Morning.
Can't hear you.
No, she's not. Oh.
No, still can't hear.
Oh, first of all, we have to wait for everybody, but there is nobody else. Oh, sorry.
I don't think so. Is there?
Yeah, I think they're supposed to be.
341. Okay.
There we go.
They're coming
And
in.
you need to unmute yourself?
I did. Can you not hear me?
Oh, now we can hear you. Thanks. Go ahead.
Morning. Oh, we're waiting.
Do we have everyone?
No, I think
These two?
Oh, no, you're right, we need two more people.
We have William Roderick checked in, Judge, but no longer on the Zoom call.
Okay, how about David Paycheck?
He's right here,
Where?
coming right up.
Oh.
So that's everybody we have on the call.
Okay, thank you very much. Wait, we don't have him.
Mr. Pajak's with us. It just looks like there's something off with his camera, but I
Okay.
believe he can communicate.
Okay, great, go ahead.
Morning, Your Honor. Mary Whiteside for the appellant Carrie W. We're asking this court to vacate the neglect findings against the appellant mother and to use its authority to dismiss this petition. We contend that if you review the evidence, it will show that she acted as soon as she learned of the severity of the allegations, showing that she had good judgment, that she took the reasonable actions that a prudent parent would take in order to protect her children, to limit them from potential harm. And that there is no showing that she made a willful admission to protect her children. The initial report came in on October 12th, 2021. Mr. O was arrested on the 20th, that same day, when she met with the caseworker, and they suggested that she file a family offense petition. She did immediately. She went to family court that very day, asking for an order of protection. And from that point on, he was barred for the house. And that was confirmed by the two oldest daughters, also the caseworker and the two oldest daughters' therapists.
We understand all that. Didn't she, however, on that first day, say that she didn't believe that it really happened?
Well, she expressed that she was, confused about it. And if you look at what came in, that, the worst testimony, the very worst testimony that came in was that she said that she had witnessed Mr. O slap Elena's butt one time. She thought that it was part of a game. And also, he expressed that he had been confused. So, and she also, as we lay out in our brief, she has some cognitive challenges, has had OPWDD services. I think when you look at the context of it, what was conveyed to her wasn't particularly severe. And once she learned of the severity, she acted immediately. I don't know that we could ask much more. And there just isn't anything more serious that came in the testimony saying what she...
I appreciate that she's using the form when she does the petition, but the box that she checked was for harassment. And she did request an order of protection for the children, but she didn't make the claim that the children made when she filed that day, even though the caseworker Burdick advised her to do so, to file that day. The bigger question I have, though, is about the order of protection. Doesn't the record reflect that on November 1st she violated it by having Mr. O back in the house?
No, I don't think that the children were not home. I contend that there is not sufficient proof that there is a violation of the order of protection in the record. There is the older children who this case is involved were all at school. And at best, it was the younger daughter, of which there's no proof that he was with the younger daughter in the record. There's no.
But she told the patrolman that she was in the process of getting the order of protection dropped when the patrolman asked about Mr. Oni coming to the house. She didn't say, oh, no, it's okay if he comes to the house as long as I keep the kids out. She said, no, we're in the process of getting it dropped. And then I think she married him the next day, right?
She was in the process of getting it reduced. She asked for a reduction for herself and for his biological daughter. That's what she asked for the order of protection to be changed to. There's no evidence that she ever made any other request.
I thought your argument was, though, that she was always in compliance with the order of protection because she kept the kids away when Mr. Oni came over.
The review of the record shows that she did keep. Absolutely. I don't contend that there's any proof that she violated the order of protection. But there is absolutely no proof that the older children that he was ever with them after the order of protection was initiated. That is just not in the record.
Do you think the record shows that she deferred to Mr. O as opposed to what her children were telling her?
I don't think that the record shows that she deferred to them. I think that any subsequent proof, because as she kept them away, the older daughters and Mr. O away from each other, the only allegations that she could have possibly deferred to them are for this alleged retribution, which I think the record is replete with evidence that the children were acting out and that she was acting as what I believe a prudent parent would do in order to limit them from unsupervised contact at the neighbors where things were going on. She wasn't making things up. There's no evidence that she was making up behaviors that the kids weren't engaging in. They were engaging in these behaviors. And the fact that they believed that it was retribution, I don't know that that's proof enough when they were actually acting out and she was placing limits on them.
Thank you.
I'm sorry, one last point. And I would ask the court to uphold that the order of protection that was issued at the dispositional hearing was illegal, that it never should have been issued, as they are biological ties and blood ties. And by marriage. And also that the length of this order of protection was too long, that also was illegal. And that contrary to the statutory mandates that work to preserve families and the family unit and to provide services aimed at reunification, that the department and the family court essentially tried to block or delay reunification via these orders of protection without going through the due process to reach that result, and that the department is now conceding that order of protection was illegal.
Okay, thank you. Mr. Broderick, Mr. Broderick isn't here, I'm sorry. Go ahead. But you need to unmute yourself.
I am unmuted. I can't get the camera to work though. Sorry.
I think Miss Maricana, is it Marican?
Marenka.
Oh, thank you, sorry. Go ahead.
Sure, Your Honor, I'm happy to. Your Honor, Mindy Marenka, I am a substitute attorney for the child Isla. I certainly concur with everything that Attorney Whiteside had stated as my brief outlines the 3 points identically. I will, though, rest on my brief, aside from just reiterating that I do believe that Carrie, the mother in this case, there's a very big difference between disbelief of allegations and absolute denial. And although there were references to her denying this, or possibly the allegations that the family court seemed to rely on in terms of her retribution towards the older daughters, much of that had to do with the disbelief that this could have occurred. But when presented with all of the evidence and the increasing allegations that there were, I do believe that she acted appropriately to restrict any access for the children with Rex, my client's biological father. She sought an order of protection, whether she filled it out incorrectly or not completely. She did that pro se, and she also sought services for herself, for the family, and for all of the children. Furthermore,
Counselor, you're saying that the accidental touching that she referred to, that's just disbelief?
I believe that the record itself and the way in which she spoke, the words that she used, the phrases she used, certainly is both indicative of some of the developmental delays and disabilities that she does have, but also just was trying to explain it to herself. Quite frankly, if it's read that way, well, I saw this when confronted by a caseworker. The caseworker's testimony was that the children told me this, and Carrie responded, "This is how I saw that." Oh, that's what happened on that day. Not as excuses, but as her own explanation.
I've seen 3 cases where this court has dealt with the situation of a boyfriend alleged to have been improperly touching children, and then the mother deferring to the boyfriend and saying, "I don't believe my kids, I believe my boyfriend, I'm going to go along with my boyfriend." In re AR, in re Peter C, in re Jennifer G. I didn't see you cite any of them in your brief. Do you feel they don't apply to this? Are they different? They seem to be right on point to me.
Sure. I'm sorry, Your Honor. No, not at all that they don't apply. I think that more clearly, though, is that there are cases that have examples of when deferring to or having some disbelief about the allegations is very different than allowing the perpetrator, alleged perpetrator, to still reside in the home, allowing the children to still be around the perpetrator. Those are cases that I did cite as well. Nicole B., Caleb LL, and that even when cases where the mother cooperated with services, she still continued to deny all of the behaviors and the allegations that were there. That is not what occurred in this case. The mother in this case did accept services, did keep the father away from the children, and there was no further allegations of any of these incidents or allegations.
Thank you. Mr. Pajak, I realize we can't see you, but we can hear you.
Can you hear me?
Yes, we can.
Okay, great. Unfortunately, I've got new equipment here and I can't get this camera to work. But
I had the same issues all the time.
okay. My client is Elena. She doesn't feel endangered by the mother. She reports that the mother's been keeping Rex away. Rex has not adopted my client. He has no legal right to visit her, and he hasn't been. Elena's happy with the situation. Rex is away. She's with her mother. I believe that the order of protection has expired along with the order of disposition. That might be open to issue, but that's my position.
Thank you. 342, Fausto Pratico versus Titan Insurance and Employee Benefits. Thank you.
Judge, we still have William on the line if you want.
Oh, I thought you told me we didn't have him.
He popped in the middle of the argument.
I don't.
Oh, I'm sorry.
I haven't been able to get my camera to work either.
Okay, everybody left.
Nope, they're still there.
Oh,
That's
line
okay.
up.
I didn't
Okay,
have
they're
anything
here.
to add.
Oh, they're on here.
Take note of it.
Come on up. Where is he?
You just won't be able to see him, Judge. He's on
That's
the line.
okay. His name isn't here either. That's it. Okay, go ahead, Mr. Broderick.
That's all right, Judge. I'm having trouble with my camera as well. So I don't really have anything to add other than to take note of the point with regard to I would also support both Ms. Whiteside and Ms. Marenka's comments, but point out that my client is derivatively neglected in this point. I don't think that the facts would also support a derivative neglect finding in this case. So I would ask the court to take note of that, particularly with regard to my client.
Thank you. Now, Fausto Pratico versus Titan Insurance. I can't believe he was doing that.
Morning, Your Honors. Michael Sullivan on behalf of the defense. Your Honors, for the better part of 4 years, my client has been defending a case.
You know exactly what your client has been doing. We're well aware.
Thank you. And damages that we've asked the plaintiff to provide for us evidence of his economic and reputational harm. And for 4 years, we've gotten absolutely nothing. To the contrary, as this motion and this appeal has shown clear and convincingly, at a great expense, my client has had to defend a fraudulent lawsuit. It has been full of lies, deceit, obstructionist behavior that knows no bounds. And the evidence that was before the Supreme Court in this motion was clear and convincing, largely unrefuted, and yet nothing happened. There was no relief given to my client. We're here today to ask that the justice system be restored, to make a message and send a message that this kind of conduct will not and cannot be tolerated. My client, I'm sorry.
Counsel, I mean, the ultimate in the justice system is your right to have a trial. How close are you being, are you going to be trying this case anytime soon?
I really, at this point, Your Honor, respectfully, I'm not sure what damages would be tried in that there have been no provable damages. And that if the fact was there was no damages, they might as well have told us that. Instead, the plaintiff has thwarted every ability for us to discover by witness intimidation.
Are we anywhere close to having a trial?
No, there's no scheduled trial as of now.
Okay, thank you.
Done.
Thank you. I think we have your argument.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. David Fulvio on behalf of the plaintiff, Fausto Pratico.
Can I bother you a second?
By all means, Your Honor.
Your client's behavior at some of these proceedings has been like startling.
Well, before the court, with respect to the motion to dismiss that's been brought by the defendants, there's an allegation of a phone call. That phone call, first off, is not material to this case. It is a collateral issue. And the proof before the court regarding this alleged phone call is insufficient. The standard, as set forth in CDR creances, is that for there to be fraud upon the court, which would amount...
We know exactly how the standard is.
Yes. Thank you, Your Honor.
Counsel complains that they haven't been able to get proof from you about what the damages are. What's your position on that? Have you been able to provide that to counsel?
Yes, Your Honor. We've provided a statement of damages which articulated the buckets of damages that Mr. Pratico is claiming. This is a malicious prosecution case, so right off the bat, one bucket of damages involves his attorney's fees in defending the criminal case that was brought against him. That was disclosed. He's alleged that he's sustained economic damages in the form of lost clients. He's named 72 lost clients, which for 2 years, the Titan defendants feigned confusion about how he could suggest that these were even his clients in the first place, when ultimately, when the case, when depositions occurred, the defendants freely acknowledged that he had a book of business, a client list, and that book of business and client list consisted of the same 72 clients that Mr. Pratico referred to. In fact, they confirmed that they contacted those 72 clients in an effort to keep them with Titan Insurance instead of following Mr. Pratico to where he was to go next. Then there's the issue of punitive damages and the malicious intent on the part of the defendants. When this case was last before the Appellate Division, opposing counsel even acknowledged that his client had no choice but to keep, to do what he can to keep those clients with Titan Insurance. So that's why he went forward with the malicious prosecution in the first place.
Let me ask you the same question that I was asking opposing counsel. So in your opinion, this is no closer to getting to trial?
We are closer. It's been Mr. Pratico's focus and determination to get this case to trial. The note of issue was actually filed in this case since it's been reassigned to Judge Doyle. But pending before the lower court is a motion to vacate that note of issue. But Mr. Pratico has been focused on the merits of his damages claim and getting to a jury.
Okay, I think we understand that.
Thank you, Your Honor.
Thank you.
Would you like me to touch upon the additional arguments raised?
Anybody have any questions?
I have no questions.
Okay. If no further questions, we'll rest on our brief.
Anissa Alley versus CVS Pharmacy.
May it please the court.
Wait just a minute, we gotta wait till the opposing counsel comes up. There, okay, go ahead.
May it please the court. Michael Sconey on behalf of the plaintiff appellant Anissa Ali. This case is an appeal by the plaintiff from a lower court order that dismissed her action against the CVS defendants. The record on this case, Your Honors, supports from witnesses, parties, and an eyewitness, sworn deposition and sworn statements, 4 separate scenarios about how this accident occurred. The lower court, however, adopted a 5th version of how the accident occurred, namely an expert affidavit from a man named Stephen Amolo. We argued to the lower court that there was no basis or no foundation for Amolo's affidavit and his opinion on how the accident occurred. Our first argument there is that Amolo's affidavit includes and is based upon uncertified police records, which this court held in the Chowjack case constitutes hearsay.
So he cherry-picked his facts, the expert?
Not only did he cherry pick facts, Justice Bannister, but based on the record, I won't want to use fabricated, but he theorized some additional facts, which might be appropriate testimony at the time of trial. And among the facts he theorized on is that the record supports that he found the maximum speed that a 2011 Kia could go, and his opinion was when the co-defendant pulled out of the driveway, she was going the maximum speed that vehicle was capable of. He also ignored the testimony of his own driver. The CVS driver gave testimony and consistently, he's testified consistently with the police report that as he proceeded down 19th Street, he saw the plaintiff standing next to a parked, stopped car in the street. Imola's affidavit tells the court that the green car came out of the driveway at a high rate of speed and the accident occurred. There is no foundation in the record for his opinion.
Okay, but Counselor, the CVS people also argue that they don't need the expert testimony, that they have their driver, correct, who testified that he had approximately 1 second to respond to this, that the car came out of nowhere. Your client's deposition said she saw nothing. The other defendant saw nothing. And the witness' affidavit I have here, the bystander who was watching outside her window, didn't see it either. So CVS's position is basically you have an emergency defense, and they've said they don't have time to respond. They're a client, so it's up to you. It's incumbent upon you to come up with an explanation as to that's incorrect.
Thank you for that question, Justice Greenwood. The emergency doctrine argument was a pivot at this court only. That was not the argument they made at the court below. The CVS driver's testimony in this case has always been, as he was driving down 19th Street, the car was stopped, parked on the street. The plaintiff was standing next to a stopped, parked vehicle. For an emergency situation, they have to prove to the court that the CVS driver was presented with an emergency. In other words, the CVS driver would have to have testified that he didn't see a car, that he didn't see the plaintiff. So the emergency doctrine was a pivot that they made only based on the appeal in this case.
Well, is that correct, or is that he didn't see the car before the collision? I mean, he could have seen the car, been not anticipated at all because it was sitting there, as you stated, and then all of a sudden, out of nowhere, I have 1 second to respond. And there's cases out of this department, too, that have said, okay, they've established their right initially, and now it's the burden shifts, and it's up to you to come forward with an explanation of, no, that's not correct. You know, we saw him look or whatever, he had plenty of time or what, that type of thing.
Your Honor, if you look at the record in this case, and would point the court out to pages 387 through 393 of the record, the CVS driver testifies the car is on the street and stopped. You raised some interesting points. Those are questions that are for a fact finder. There needs to be a trial to filter these things out. Because the lower court and the affidavit of Imola was based upon hearsay, the defendant did not meet their burden of proof. And we further ask the court to consider the sworn statement that a Tasha Rudolph gave to an investigator for the principal for co-defendant McGuire. The lower court refused to adopt or acknowledge her statement, and there is comments in the court that he found the statement to be incredible, and based upon case law that we cited in our brief, it's not the court's role to judge credibility of witnesses. We say that the lower court order should be reversed, and the appeal should be granted, and the plaintiff's cross motion for a summary judgment on negligence should be granted. Thank you.
Thank you. Go ahead.
Good morning. May it please the court, John Hanson from Monaco Cooper, Lamy and Carr on behalf of CBS and Mr. Butler Clyburn. Justice Greenberg, Justice Greenwood did an excellent job of summarizing our position, so I'm not going to go too much beyond that.
I'll ask you a few questions then, okay?
Okay.
So your motion for summary judgment, you include the depositions of the plaintiff, McGuire and Clyburn, and my reading of them, and believe me, I read them, they were quite incredible, okay? I mean, and I don't mean it in that determining their credibility, just the stories are so outrageous, every one of them, okay? But the three different depositions that you put forward have three different versions of how this accident happened. In my view, okay, let's just go through a couple of things. There's questions of fact with regard to how fast the McGuire vehicle entered the roadway. You put forward her deposition at which she says that she lifted her foot off the gas, no acceleration. Clyburn says that there was some acceleration, and the plaintiff says that the acceleration was so great that her feet were lifted off the ground to the point that she was parallel to the ground, okay? So I see, that you've offered, in my view, three different facts from three different people about how she entered the roadway, which I think has some application to whether the emergency doctrine applies and or is dispositive of this case. Where the defendant's vehicle was, or the McGuire vehicle was, they all have a different opinion about where that vehicle was on the roadway beforehand. And I think you would probably agree with that. They all have a different opinion. And the thing that counsel for plaintiff brought up, and then I'll let you respond, okay, was the fact that Clyburn, your client, said that nothing blocked his view. In fact, he gave a recitation of watching the plaintiff walk out, walk to the car, have a discussion with McGuire, and so there was nothing blocking his view. And he also had the ability to not go any further. He could watch it happen. He doesn't have to go. He doesn't have to go around. So why don't you talk about the different stories that I'm reading in reading that record of the different people who gave depositions that you presented to us.
Sure, Your Honor. Thank you. I agree. This is a fantastic story that probably wouldn't be believed if it was fiction. But I think what's important to do in a situation like this is focus on what everyone agrees on. And I think what everyone agrees on is Butler Clyburn had the right of way. Whether the McGuire vehicle, the plaintiff's vehicle, was stopped on the side of the road or whether it was stopped in the driveway, regardless, it's stopped. It's not proceeding forward.
Or halfway in the road, as one of them says. Okay, but go ahead.
Even if halfway in the road, Your Honor, it's clear that the McGuire had gone to the plaintiff's home to check because an alarm went off, and there's a whole thing that's going on there, and a confrontation with the plaintiff, and Butler Clyburn is entitled to proceed in the roadway there, and what's undisputed again is he testified that he was about even with the McGuire vehicle before it started to pull out. I mean, that is the basis of the emergency doctrine defense, and I have to dispute what my adversary said. That is absolutely what we argue down below, that because he was so close to the McGuire vehicle before it pulled out that he didn't have time to do anything about it. That he saw it, he was operating his vehicle reasonably. There's no testimony that he wasn't paying attention, that he was on his phone or anything like that. But this vehicle all of a sudden pulled right into his lane of travel, and then he had no.
I'm sorry.
I apologize.
Well, that's kind of the point. No matter what the extraneous testimony is, that's what we should be focusing on. Is that your point?
Yes. The point is without proof that he was doing anything wrong on the road, and that but for that wrong, the accident could have been avoided. That is the emergency doctrine. So even if we take the Rudolph second statement that he was flying at 40 to 60 miles an hour, even though Supreme Court found that there's a foundation for that opinion, even if we accept that, there's still no proof that he wouldn't have, this collision still wouldn't have happened because the Butler-Clyburn or the McGuire vehicle started pulling out so close.
Okay, so McGuire, however, says, counsel, that there was no acceleration. All she did was merely pick her foot off the gas, or off the brake. So if somebody was going that slow, you know, how that feeds into the whole emergency doctrine. You know, it would need to be going so fast you couldn't do anything about it. And I admit 2 out of the 3 depositions that you presented below have that premise, that she was going so fast. But there is one that says, oh, I just took my foot off the brake. You know, so I guess what I'm saying is, aren't you asking us to make credibility determinations that 2 out of the 3 of them were right and 1 of them was wrong?
Our position would be, no, we're not asking you to do that. We would never ask you to do that, Judge. That this is a situation where, again, our driver was proceeding with the right of way down the roadway, and a vehicle came into his path. And he was near even with it, whether the vehicle was going 2 miles an hour or 10 miles an hour or 20 miles an hour when it pulled out. The point is, it happened right as he was coming upon it, and under the circumstances, that's the emergency doctrine. Admissible proof that he was doing something wrong and could have avoided it had he not been doing anything wrong. And Supreme Court correctly found below that there was no admissible proof.
Counsel, on this record, don't we have to assume that the McGuire vehicle pulled out of the driveway? We have to. We have to give that to them on summary judgment, on your motion, right?
Yes.
Okay, so therefore, your client, Clyburn, then when he testified that the vehicle was on the side of the road and that he was pulling alongside the vehicle, we have to assume either he didn't really see it, that he was mistaken, or that he was lying. We have to assume one of those, right? Because we have to believe the first premise on the record. The jury doesn't, but we would.
Judge, I think this is one of these situations where there's a pretty crazy thing that happened, and there may be differences of opinion.
Wait a second, but we have to credit the plaintiff's testimony and the McGuire testimony and the other witnesses' testimony and your expert's testimony that says that Clyburn either was mistaken or lying. So don't we have to accept that right off the bat? And then once we do that, how could we not perhaps see a possibility that Clyburn did see what was happening and thought, these two are horsing around trying to grab the wheel, they're pulling in front of me, I'm just going to go around them instead of waiting for them to resolve whatever their issue was? Why can't that be a possible conclusion by the jury based on the record?
I think that with a vehicle stopped on the side of the road or in the driveway, wherever they were, that Butler Clyburn had the right of way. He doesn't need to anticipate that the vehicle is going to pull out in front of him. He's entitled to proceed. And the fact that this vehicle pulled out in front of him right as he was approaching it didn't leave him time to avoid it.
Okay. I think we have your argument. Thank you.
Thank you.
Irwin versus St. John Evangelistic Church of Greece.
Good morning, Your Honors. Carl Dibble from Bonchen and King for Defendant Appellant St. John the Evangelist Church of Greece. The lower court wrongfully denied the church's summary judgment motion because the evidence in the record shows the church did not have actual or constructive knowledge or notice of the icy condition that plaintiff allegedly fell on. Plaintiff alleged notice on this case in a
Why did the priest then throw ice down or salt down in that area?
Well, first the priest testified that it wasn't icy, and then the priest also testified.
Salt down.
Yes, he did.
Why would he do that? He aware that there was salt or ice in that area?
He explained later that was just that's something he's done for years, and that's part of his morning routine in the winters to walk around and throw ice where people come in before Mass.
Where ice might accumulate and people might slip.
Sure, and
Where traditionally ice is accumulated. Right.
Yes, but that doesn't, plaintiff alleged notice of the ice, in this case, based on water dripping off of the roof. Our evidence in the record shows that that was not possible, so there's no other way to get the notice in this case. The ice was clear, Father Peter didn't see it, the plaintiff didn't see it. There's no other way besides knowledge of this recurring condition, and the evidence in the record.
The impossibility, just so I'm clear on the argument, is because the weather forecast showed that the temperature was under 32 degrees, and therefore every place in the area had to be under 32 degrees, even if it's right outside the door of a building where inside the building it's 70 degrees. Your argument is that 1 foot away from that building, it's under 32 degrees.
Well, the plaintiff's fall was, I think, more than 1 foot outside.
I'm not a meteorologist.
Yes,
but that's your argument. Your
Yes.
argument is that when it's under 32 degrees, every place outside is under 32 degrees, regardless of what it's next to.
Well, our expert opinion said that based on the weather data, that it was impossible for snow to, and given those conditions, it was impossible for snow to melt from the roof and then also at the same time refreeze underneath the roof. And the plaintiff has failed to rebut that with any competent expert. I mean, the plaintiff's expert in this case is not qualified to render these sort of weather, snow melt opinions. He alleged no special knowledge or education or training.
Some of it's just common sense, but go ahead.
Sure, but I think the common sense, if we're going to go that route, I think the common sense supports our position, is that the weather was freezing for a week up until this time. If water did happen to be dripping, if it melted, it wasn't going to refreeze because the weather was warming up. For this condition to happen, the weather would have to be below freezing, above freezing, and then back below freezing for the water to melt, and that there's no evidence to support that in this case. And I also, as far as meeting our burden, I want to point out the fact that Father Peter, when he did his inspection, he didn't see water dripping off the roof. The plaintiff didn't see, after she fell, she didn't see water dripping off the roof. So none of that, all that evidence supports the fact that, this recurring condition was not the basis of the fall.
Anything further?
Unless your honors have any further questions, I think we can rest on our briefs.
Thank you.
Good morning. May it please the court, Craig Chartier on behalf of Joan Irwin. I think the record here is pretty clear that the church had noticed that this hazardous condition was reoccurring. The snow is melting off the roof. It's freezing on the walkway below, right in the entranceway. Father Peter testified specifically he's aware of that condition. The weather data does not show that the conditions leading up to the fall were such that the snow could not have been melting off the roof. We've got both temperature data and snow depth or snow melt data that were part of the expert's opinion that just don't match up with the appellant's arguments. Father Peter also testified that the snow was melting under the sun the previous day. Father Peter's testimony changed as well. He initially testified that the day of the accident, water was actively dripping off the roof. He later changed that testimony to be that the water sometimes drips off the roof. Now, even with that change, it shows, well, even with the change, he also testified that the conditions were such that morning that he had the salt. He never specified what those conditions were. We have testimony here in direct conflict as well. Father Peter testified he salted the area where Mrs. Irwin fell. She testified that she did not see salt in the area where she fell. She testified that the ice she fell on was visible probably from about 5 steps away. She didn't see it initially when she exited the church, which was about 10 steps away, because she was looking forward, not down. The church even posted a sign or a cone in the area where the ice accumulated, It's not clear that that was there on that day. There was some.
Nobody knew if it was there, nobody remembers if it was there or not.
That's correct. And for remaining points, I would rest on our brief, but for these reasons, the lower court's decision should be affirmed. Thank you.
Thank you. Roos versus City of Syracuse Department of Public Works. Oh, you need to sign like that.
Good morning, Your Honors. Matt Kaiser for the appellant Rakesia Rose. And I just want to begin my argument by focusing on a procedural point that's raised by the respondents in their brief. And that's a procedural point that really attacks the vitality of all the motion practice below. And really, the essence of the argument is that this entire appeal is a nullity because they would be able to raise this affirmative defense or this substantive defense at trial in any event. Judge Karolounis converted our motion to dismiss the affirmative defense into a motion for summary judgment. Judge Karolounis never held that the only framework or avenue to litigate whether the statute applies and whether the statute provides the substantive law defining the extent of the duty of care is through a determination of liability. Liability would enable the accrual of prejudgment interest, and it would be sufficient to litigate this question, but it's not necessary. We cite a number of cases, including Sasso from 2015, where the recreational use statute was properly litigated in the context of an affirmative defense. And it was in Ferris that the Court of Appeals held that the recreational use statute did not need to be raised as an affirmative defense. So, I mean, the argument does not make sense. We feel like we're procedurally proper here, and the question of whether the statute applies and whether it defines the duty of care is properly before this court based on the motion practice below and based on this appeal.
So below, you didn't simply ask for dismissal of the affirmative defense. That may have been the initial part of the motion, but you then asked for a pretrial determination on the applicability of 1103.
Exactly.
And the judge gave you that determination, which you disagree with.
Right, exactly, Your Honor. We are thoroughly aggrieved by that determination because it is the law of the case going forward. And when we go to trial, the trial is scheduled for August. I can guarantee the defendants will be pointing to that pretrial determination saying, no, Judge, this is you got to charge this statute. So that's why we're here today, and we think that this appeal is not moot, and we ask this court to really probe the merits. And kind of turning to the merits, I mean, if you look at the structure of BTL 1103B, there's two exemptions here. You get the broad exemption for when you're actually engaged in work on a highway, and you get the narrow exemption from stopping, standing, or parking provisions when you drive a hazard vehicle. In 2016, the legislature amended the definition of hazard vehicle, expanded that definition. But that's all it did. That's as far as the legislature went. And so the statutory definition doesn't define the duty of care here. BTL 1103 does. And the Second Department's decision in Guzman is right on point. This court isn't bound by it, the court below was, but we think that the decision in Guzman is well-reasoned based on, the plain language of the statute and legislative documents surrounding the statute. And, Guzman is good law. It remains good law. And that's our position here today.
So we should treat this, or the court should treat it at trial as a car accident?
It's a car accident
motor
case.
vehicle accident. No special immunities or protections of 1103.
Recycling trucks should stop at stop signs and yield right away.
Tried to make it through. You did stop.
Thank you, Your Honor.
I can do it.
Good morning. May it please the court. Darian Balin for the City of Syracuse. The only relief that plaintiff requested, even once the motion was converted, was, quote, an order granting this converted motion in its entirety and striking/dismissing from the answer of the defense the 15th affirmative defense. Plaintiff was given the opportunity to request the appropriate substantive relief when the motion was converted. Judge Karolounis said this isn't appropriate to litigate as a motion to dismiss, converted it to a motion for summary judgment. And then plaintiff should have requested the substantive relief on the applicability of 1103, but instead only requested the dismissal of the affirmative defense, which was exactly what was requested before. And so for those reasons, the city's position is that whether or not the affirmative defense was stricken, we would be able to go forward on this, and therefore the decision of the lower court should stand.
And I really don't understand that logic one bit. You know, I mean, if this statute is removed from the case, but right, you know, why would you then be able to ignore it and then bring in evidence of that anyway? Because that's what you just said, right?
Well, no, so what I said, Your Honor, is if the city wasn't required to plead 1103 as an affirmative defense. So whether it is an affirmative defense or it's stricken as an affirmative defense, we would still be able to request a charge of the substantive defense. So whether it's an affirmative defense in the city's answer or not doesn't actually get to the substance of the applicability of 1103, which the city would be able to raise even if we had never asserted it as an affirmative defense.
Not if we say it's not.
Of course, Your Honor. If there's no further questions on this matter.
Thank you.